Good afternoon. Hello. Are we ready to start? Yeah. Hello. Welcome to DIIS, the Danish Institute for International Studies, and welcome to this seminar on the importance of archives in decolonization processes in the North and the role of international law. Both to you here in the audience, I'm very happy to see that many came, and to you who are following on the live stream. I'm Astrid Nonbo Andersen. I'm a senior researcher here at DIIS, doing research on a variety of stuff relating to the relations between Denmark and its former colonies, but also more recently to truth and reconciliation processes in the Nordic countries, together with Rachael and Mullins, who are also here in the audience today. The importance to archives, to processes of decolonization, has received increasing attention the past couple of years. Archives are not just dusty records hidden in old boxes with little relevance to the present. The archives in question this afternoon include sagas, myths, and tales dating thousands of years back, colonial records, treaties, and documents written by colonial officials, but also letters and diaries, testimonies and witness accounts created by colonial subjects, survivors, and other people, and archives that are captured in a wide variety of media, from medieval parchments over audio and video recordings to kills and carvings. Sources that in each their way can tell us something about the stories of individuals, families and communities, and also peoples, nations, colonies and states, and to what I've called historiographic sovereignty in a recent paper. The rights and abilities of people to write their own history. As such, archives have played and continue to play key roles in processes of decolonization, claims for self-determination and sovereignty, and to processes of truth and reconciliation that have and are taking place across the world, including the Arctic, Canada, and the Nordic countries these years. And we're struggling a bit with finding the best capturing word for this region that we're talking about. The aim of this seminar is to bring lawyers to the topic, long studied by indigenous and other experts in archives and history. We seek to highlight legal aspects and the role of international law in this context. The themes will touch on questions such as archival ownership and custody, the problem of displaced archives, the rights to access and own archives relating to one's own histories, the right to know, and the question of what an archive actually is, just to mention a few of the themes that we will be covering this afternoon. Today's distinguished speakers will share their knowledge and experiences from quite different contexts, territories, empirical background and theories, and I know this counts to many in the audience too. So with this seminar, we really hope that we are able to open a new dialogue, create reflections, and facilitate new learning on these topics. And so I'll end this short presentation here by just encouraging you also in the audience to use the opportunity to ask questions and bring your own experience forward, both in the Q&A sessions, but also in the coffee break and beyond. So, all that said, I'll give the floor over to Rachael Lorna Johnstone, who's a professor of law at the University of Akureyri and Ilisimatusarfik, University of Greenland. She specializes in polar law, the governance of the Arctic and the Antarctic under international and domestic law. She has published widely on decolonization under international law, the rights of indigenous peoples, and international human rights law. And she is also the leader of the series of workshops that this seminar is also part of. Right now, I just forgot the title of our project, but I give the floor to you.
Thank you, Astrid, for that introduction. So this research, from my point of view, started in 2019 at a conference organized by Astrid here at DIIS on truth and reconciliation in the Arctic in 2019. I wasn't here, I wasn't following it live, and in fact, it was during a quarantine in November 21 when I finally caught up with the recording of the seminar. And a presentation by Inge Seiding gripped me. She was the head of the archives, Greenland National Archives, and talking about the challenges that Greenlanders face both at an individual level and as a collective of accessing their own history. And I thought, this is surely a matter of self-determination. There must be a bunch of international law about this. In 1960, the General Assembly confidently asserted that inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence. Gott och väl. International law, therefore, requires that people govern their own land, their own resources, their own human persons, and even others who are on their territories. So surely it's not too much to expect that they govern their own written records. Yet here we are, 64 years on. So I reached out to Inge, who then directed me to James Lowry's work, and the rest, as I say, is history. I looked at the Greenland Reconciliation and the project that Astrid mentioned before, and the first recommendation of the Greenland Reconciliation Commission is that Greenlanders tell history through their own eyes. Astrid has developed this concept of historiographic sovereignty, the rights of peoples to control the narratives about them. And how can we do that except with access to the historic record? And when we say archives, not just written words, but other ways of accessing history. So I looked into the international law and I found a 1983 Vienna Convention that dealt with property, archives and debts. It has 7 ratifications, needed 15 to come into force. That means doesn't really tell us anything. It's not, doesn't have any strong legal basis. Jamila Gadar has also written extensively on this topic. But it's also from 1983. And there's a lot of developments in international law on decolonisation since then, both as regards to independent states and as regards people who remain in colonised territories, for example in Greenland, or indigenous peoples elsewhere in the Arctic and beyond. We have ILO Convention 169 on indigenous and tribal peoples, to which Kingdom of Denmark is a party. The much better known UN Declaration on the Rights of Indigenous Peoples, developments in international human rights law, especially under the right of members of minorities to enjoy language, culture and religion, which is now being applied by the relevant UN body in a way that implements the UN Declaration on Rights of Indigenous Peoples. And through reconciliation processes and increasing interest in the concept of the right to know. Yet there was no link I could see in the research, or no significant systematic research that linked the application of all this international law on decolonisation to the matter of contested archives. So since 2022, I've been trying to bring people together, the experts in archives and history who've been doing this work for a long time, with the experts in international law, to whom I could see very little work, with some honourable exceptions, including Armin Savarian, who is in the room today. 2023, a year later, at the Polar Law Symposium in Tórshavn in Faroe Islands, we launched an Arctic Archives subgroup of anyone who's interested. This is under UArctic Thematic Network on Arctic Law. You definitely don't have to be a lawyer. You don't have to be an archivist. You don't have to be a historian. You don't need to know anything about the Arctic. You just have to be interested. So please look that up if you want more information or ask me about it. And it really is a very clearly non-hierarchical place for us to just discuss these ideas and think about what we don't know and what maybe we can find out. I'd like to thank the funders. So Nordforsk is primarily funding this seminar and the workshop around it through the project Decolonising Nordic Archives. We have additional funding from the International Arctic Science Council Social and Human Working Group for decolonising archives in the Arctic. So I'd just like to thank you all for making the journey here, both physically and intellectually. And without putting pressure on today's speakers, just to remind you, the reason we are here is a seminar at DIIS in 2019. So you never know who's listening and what's going to come of it later. Thank you very much.
Yes, and now I have the honor to introduce Raymond Frogner. Raymond is the head of archives and senior director of research at the National Center for Truth and Reconciliation, University of Manitoba. Raymond Frogner researches and publishes on archival issues with a focus on indigenous societies, identity and memory. Moreover, Raymond is responsible to respectfully honor, safeguard and, when appropriate, make available the records acquired by the TRC and additional records of enduring value for indigenous peoples. And without further ado, welcome.
So let me just make sure everyone can hear that. It's working okay? Okay. Tanse, Raymond Netigason, Notari Oscar Egua Nigari Doris Netatoscan, National Center for Truth and Reconciliation. Bonjour, je m'appelle Raymond, je suis le directeur de recherche et le directeur des archives pour le Centre national pour la vérité et la réconciliation. Hello, my name is Raymond. I am the archivist and head of research for the National Center for Truth and Reconciliation. I want to thank the organizers of the conference and the Danish Institute for International Studies for kindly inviting me. This is my first visit to Denmark, and I look forward to an engaging conference and exploring beautiful Copenhagen. The National Center for Truth and Reconciliation, the NCTR, where I work, is located in Canada on Treaty 1 territory. These are the ancestral lands of the Anishinaabeg, Anishinaabe, the Kodo Yate, the Nesulene, and the Hewitak nations. This is also the homeland of the Red River Métis, and in the north of the province, the ancestral lands of the Inuit. The NCTR respects the spirit and intent of treaty making and remains committed to working in partnership with Indigenous peoples in a spirit of truth and reconciliation. In a speech delivered to the NCTR in 2022, Honorable Murray Sinclair, a former commissioner of the Truth and Reconciliation Commission of Canada, recalled his legal studies at the University of Manitoba. As a young Indigenous law student, he described a meeting with a group of local elders and knowledge keepers to discuss community laws and cultural practices. To attend the meeting, he was taken on a journey in the back of a pickup truck along winding unpaved roads deep into the bush. When he asked why they were meeting in the backwoods, he was told it was because some of the traditional laws and cultural practices they would perform and discuss were not fully endorsed by settler authorities. Indigenous leadership took this knowledge underground to escape persecution. This anecdote illustrates the gradual and purposeful erosion of Indigenous knowledge practices and worldviews in the colonial era. The progressive loss of cognitive social bonds, community memory, cultural identities, and normative natural laws resulting from the overwhelming assertion of imperial sovereignty and uncompromising colonial settlement. The attrition of Indigenous cognitive landscapes occurred in coordination with the physical loss of lands. Indigenous legal scholar James Sakej Youngblood Henderson has described this unfolding Indigenous colonial experience as the ideological twins of violence and imagination. Violence controls the physical context of genocide and legal authority, while imagination controls the intellectual justification of violence and in the context of cognitive and cultural imperialism. If ever we are to braid together our respective intellectual worldviews, acknowledge our mutual humanity, dignity, and human rights, we must create a meaningful cognitive space for Indigenous ways of knowing in our academic, social, and professional fields currently built on specific Western bodies of knowledge. This quest begins by acknowledging not just physical removal of communities, but the co-opting and absorption of Indigenous cognitive understanding, the ideological violence practiced on Indigenous imagination. In the colonial relationship between Indigenous peoples and imperial/settler authorities, religious, legal, and cultural, there's always been an ongoing tension between the formal, legal, and statist methods of enshrining, valued, and sanctioned memory, what James Tully has called the universal pretensions of the juridical, and the implicit, sacred, and immanent Indigenous order pre-existing in local contexts of nature and humanity. As Harold Berman describes in his work Law and Revolution, this inherent tension between the innate human rights and statist authority has resulted in well-known people's revolutions, French, English, Russian. The UN Declaration on the Rights of Indigenous Peoples, or UNDRIP, is the most recent example of these revolutions. To find pathways for a meaningful framework of international rights that incorporates the lifeways of Indigenous peoples, we must recognize this inherent tension between the latent normative order of Indigenous peoples' rights and human rights understood as the will of the sovereign. Until recently, histories of the colonial encounter commonly assumed the imperial imaginative depiction of Indigenous knowledge when predominantly unchallenged. The overwhelming cognitive impact of colonial settlement simply engulfed and eroded Indigenous epistemologies and self-sustaining ideas of natural law and immanent collective social organization. But centuries of colonial engagement demonstrate the Eurocentric legal tradition of imposed order of a sovereign has never been able to fully exclude the immanent, sacred, or community law, those collective cognitive social principles that supported Indigenous societies for generations before colonial contact. In fact, Indigenous intellectuals and representatives have consistently refuted Enlightenment social paradigms of individualism with arguments for immanent community values, respectful acknowledgement of diversity, and an inherent spiritual relationship with local ecology shared through performance, language, and cognitive material expression. Colonial encounters were complex and multidimensional relationships, and as with all intimate and significant relationships over time, the influence was both profound and reciprocal. Inevitably, through ongoing contact, a thread of indigenous influence colored the weave of Western epistemologies of governance and social theory. European social theorists borrowed freely, if not admittedly, from the fabric of indigenous social thought. This indigenous epistemological influence can be found in our institutions of governance, in our mechanisms of social representation, and our public spaces of culture, heritage, and social memory. It is these same epistemological lifeways that we must acknowledge and revive, decolonize our traditional archival memories, to bring the international views on human rights into a meaningful relationship with local indigenous societies. Yes. As this conference theme notes, archives are contested assertions of authority. Today we are dealing with the concept that shared, displaced, and disputed archival heritage is a matter of global concern. To make my point, my presentation traces 4 periods in the evolving imperial-indigenous relationship in Canadian history. I characterize each period with archival examples to highlight when juridical authority asserted its contested jurisdiction and indigenous peoples responded. In each period, the character of the archival record reflects the character of the relationship. I know that's a lot of text, but I have 30 minutes, so. I begin with the formal sustained British contact with non-Christian societies in the 17th and 18th centuries. This relationship can be characterized as a kind of residual medieval and personalized sovereign authority. British imperial authority acknowledged indigenous identity and worked closely with indigenous representatives. This recognized indigenous nationhood had limits. Indigenous peoples were viewed as subjects of the crown, which held clear underlying jurisdiction. This form of recognition was expressed in treaties, sovereign protocols, and proclamations. From an indigenous view, intersocietal recognition and accommodation across communities of equals has been a traditional indigenous governance model. Political order in indigenous societies has emerged from collective and respectful consensus, cultivating relationships of spiritual kinship, linking individuals, communities, and the natural world, not from the coercive will of the sovereign. To maintain a sense of ordered freedom within these societies requires that individual communities honor the sacred duties of care and respect that ties of spiritual kinship imply. The original treaties, created from the mid-17th to the early 19th century, acknowledge these traditions of social organization. The exchange of the 2-row wampum belts in Niagara in 1764 is an example of indigenous intersocietal expression. Indigenous authorities created these items to enshrine the sovereign indigenous rights recognized in the Royal Proclamation of 1763. And so here they are side by side. Commissioner Murray Sinclair of the Truth and Reconciliation Commission has referenced the lost opportunity of respectful independence captured in the proclamation and the promise of self-determination captured in the Niagara ceremony. No less than the proclamation, the wampum belts formally acknowledged and notarized a respectful relationship. They symbolically depicted 2 peoples traveling parallel but independent paths, and the white spaces in between is supposed to symbolize peace. In 2015, the Truth and Reconciliation Commission's final report included 94 calls to action, activities to reconcile the colonial relationship between settler and indigenous societies in Canada. Call to action number 45 recommended a renewed proclamation with a social protocol of the wampum to cast a new post-colonial model for indigenous settler relations. I've already buried my... By the second half of the 19th century, the Crown had abandoned these relationships of mutual esteem. Common law produced a positivized doctrine of Crown sovereignty that shaped the political relationships with indigenous peoples. Law became more of a blunt force instrument for indigenous dispossession. Proof of sovereignty became documentary evidence of ownership of land captured in land title registers. Pathways of indigenous self-determination became limited to the stifled forensic arguments of colonial common law. The Cowichan Petition of 1909 is a model document of this era. It is a direct indigenous response to what I would call settler authority's great period of assimilation, or the period of great assimilation. It is thought to be the first official document to make the legal argument for Aboriginal rights and title written in legal formality. The Cowichan petition was written by lawyers Clark and O'Meara in 1909 under the direction of Cowichan elders from Vancouver Island. The document was sent to the British Colonial Office, the BC government, and to Ottawa. It influenced the Nisga'a petition of 1933, which eventually led to the vital 1973 Calder Supreme Court decision. That decision is generally thought to be the dawn of the modern era of Indigenous judicial activism on rights and title in Canada. There was no other time before the 1960s that Indigenous people were closer to forcing Canadian courts to adjudicate the land question than the 2 years between the presentation of the Cowichan petition in the spring of 1909 and the Dominion election of 1911, when the Liberal government of Wilfrid Laurier, responsive to the arguments of the Cowichan petition, lost the election of 1911. The incumbent Conservative Party quickly passed a bill making it illegal to raise funds for the purpose of campaigns for Indigenous rights, and made it virtually impossible for lawyers to represent Indigenous peoples in court. The Indigenous Residential School System, or IRS, is another product of the colonial empires of uniformity and assimilation. Begun in the 1880s, for 160 years, settler authorities administered the IRS program to assimilate approximately 150,000 Indigenous children into settler society. 7 generations of children endured physical, emotional, and sexual abuse, want of proper health care, educational standards, malnutrition, and even death. This period lasted until the last quarter of the century. I cite one example, a photo from the cemetery of the St. Joseph's or Nonbo IRS, as an example of the childhood experiences of these schools. The disclaimer I am showing is the caution that the NCTR employs for all disturbing images on our website. So I caution the audience this is an unavoidably disturbing image of an unsettling story. This is a photo from 1918 of a gravesite near St. Joseph's or Nonbo IRS. It depicts 27 women and girls attending to a graveyard with crosses and gardening equipment. It's a posed photo. The girls are wearing summer hats. They are facing the camera and have not yet begun work at the gravesite. This is a type of propaganda photo common for its time. In their constant effort to convince the federal government to fund their IRS work, religious orders such as the Catholic Grey Nuns, who operated this school, would regularly accompany their quarterly reports and correspondence with images giving proof of the social purpose and legitimacy of residential schools. Such photos were commonly circulated in news bulletins to Catholic audiences located predominantly in the province of Quebec, from where most of the IRS teachers in Western Canada, significantly priests and nuns, were recruited. The school was one of the first 3 industrial schools set up in Western Canada in 1884. A federal order in council gave the Catholic Oblate Order responsibility for the Treaty 7 area, encompassing the southern region of the province of Alberta. Father Lacombe, a leader in the history of the Oblate Order in Canada, set up the school. The Blackfoot, now known by their proper name, Siksika community, was one of the closest reserves and the subject of Lacombe's attention. Funding from federal government was directly linked to enrollment numbers. This led Father Lacombe's successors to cast an increasingly wider net for students to attend Nonbo. Over the next decades, Cree, Métis, Sarsi, Tsuut'ina, and Stoney Indigenous community children were recruited. In all, Nonbo Industrial School operated for some 38 years with a total of approximately 430 students attending. Health conditions at Nonbo were always poor. Indigenous children lacked resistance to European diseases. The operating agreement included the provision for a medical doctor from Calgary to pay regular visits, but this rarely occurred. Students were almost constantly sick with colds, influenza, and particularly tuberculosis. Records indicate by 1909 virtually every student at Nonbo had TB. Quarters were so tight, healthy children were forced to sleep in the infirmary, exacerbating the spread of disease. At last estimate, 73 students died at the school, which closed in 1922. That's 1 in 6. To date, 34 children who were interred in this graveyard have been identified and named. The NCTR has an online memorial site that commemorates students who died in our 141 IRS schools. This particular cemetery is near the edge of Highwood River. In 1996, flooding eroded the banks. Caskets and bones spilled into the river and remains washed away. Environmental erosion occurred at several schools across the country, including Cooper Island, Assiniboine, Muskowgan, and Brandon, to name just a few. This is a direct result of the poor or non-existent care these burial sites received. There is no federal gravesite legislation in Canada. There is only a patchwork of provincial laws that apply to unmarked burials, gravesites, and collective remains. Canada has struck a special interlocutor to investigate and recommend on this situation. The Nonbo site fell into a no man's land in terms of Alberta provincial government jurisdiction. Too young to be archaeological, too old to have been recorded as a cemetery in provincial records. No government department was immediately prepared to step forward and assume responsibility for the disposition of these remains. Referencing the conference theme of displaced archives, to research this photo, one must consider multiple sources, government clergy, public and private. And just to be clear, when we received this photo, none of the children were named. In the case of the Nonbo IRS, the records of the Grey Nuns, located in their Montreal Archival Centre, the records of the Oblate Omai Lacombe, located in the Provincial Archives of Edmonton, and the federal government sources in Ottawa in Library and Archives Canada are the most important sources of documentary evidence. This must be read in the context of community social memory. Cross-indexing the records, it's possible to identify the names of who was in the picture by examining the discharge records of the school and the annual reports of who attended. These are the reports that were submitted to the Department of Indian Affairs. All of this must also be read in the context of the Indian Act, which did not mandate that an IRS principal formally report the death of a child until 1935. It is also possible to review the original discharge register to confirm what were often inconsistent reports. It is not uncommon to find important information written into the comments of the discharge records. Furthermore, the children were often given European names and numbers for recording in registers, and this must be confirmed. Different registers frequently had different spellings or identifications for the same child. There are examples of children with over 15 different spellings, languages, and numbers identifying the same child in our records. The school's day journals are also a useful documentary source. In this case, the journals note that the children who learned farming dug the graves, and boys who learned carpentry made the coffins for their classmates. Another journal indicates that during the influenza outbreak, more than one child was placed in a coffin due to resource restraint. Also in these journals, I determined the local Indian agent was instructed to give a special pass to permit a family permission to visit a child at school once a year, more often if the child was sick. With the photo from the Grey Nuns, the report from Indian Affairs, and the journals from the Oblates, it is possible to weave together an impression of the IRS experience and get a view of the nature of the contested archives of residential schools in Canada. Together with the testimony of survivors, we begin to get a glimpse of the Indigenous experience of the period of Great Assimilation. I'll now return to the conference theme of international rights and revolutionary breakthrough of the UNDRIP. This UN declaration builds on a latticework of post-war international statements on human rights. Notably, UNDRIP Article 3 draws from the first article of the two 1966 UN Covenants on Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. These two covenants expanded on the 1948 Universal Declaration on Human Rights. The covenants continue to elaborate on the international legal trajectory of highlighting human rights over state values, which began in 1948. As Andersen has noted, the idea of inherent human rights is an entirely new frame of reference in the history of Eurocentric legal thought and traditions. The covenants are a breakthrough because they forcefully introduce human rights as a judicially cognizable and enforceable entity. They also advocate for a collective self-determination, a core issue of the Indian rights movement, or Indigenous rights movement. Through the covenants, Indigenous representatives expanded on the contemporary distinction between peoples holding the rights of self-determination and minorities holding the right to cultural integrity. Indigenous representatives in Canada recognized in these thoughts the potential for their own struggles for recognition and supported the development of the Universal Rights Program. Indigenous peoples formulated their own collective right arguments, tying together the mid-20th century rights model for self-determination, minority, and human rights. For example, as early as 1964, in the closing arguments for a local legal case involving Indigenous deer hunters, known as R.V. White and Bob, the lawyer Thomas Berger cited the UN Declaration on Human Rights, a Universal Declaration on Human Rights, in his closing remarks. As he noted, it was only 15 years since this formal international recognition of human rights. It must certainly apply to Indigenous peoples. At this early time, Indigenous activists were already formulating their ideas on the international human rights movement. In international colonial jurisprudence, this case is notable but underappreciated for its early date and insight. With full credit to Indigenous activism, the covenants influenced domestic Canadian discussions on Indigenous rights in both legal and political spheres. Canadian public discourse absorbed the growing contemporary international human rights consciousness in its public policy dialogue on Indigenous rights. International forums on Indigenous rights influenced the tone of such domestic work as Section 35 of the 1982 Constitution, recognizing, quote, existing Aboriginal rights, unquote. It also informed the arguments of activist public litigation law that enabled Indigenous rights campaigns across Canada. With full credit, the influential idea of inherent human rights since the Covenants has been confirmed in several important international declarations. But the fundamental question remains how to resolve, at a local level, the basic tension between legal doctrines founded on the latent Indigenous normative order and laws the will of the sovereign. In the last quarter of the 20th century, domestic Indigenous rights campaigns began to meaningfully incorporate international advances on Indigenous rights and human rights in general. The taproots of Indigenous thought and law resurfaced in a new form of Indigenous jurisprudence, which braided together colonial common law and the unique inherent rights and thoughts of Indigenous peoples. 3 legal developments facilitated this jurisprudence. First, the judicialization of the Constitution reshaped the nature of the relationship between the executive and Indigenous citizens beyond the previously mentioned subjecthood. Second, developments in human rights law made these rights judicially cognizable. And third, the emergence of class action claims provided a method for Indigenous communities to legally advocate for their concerns, one result being the largest class action suit in the history of the country. With these developments, Indigenous activists forced the federal and provincial governments and related Christian organizations to agree to a class action settlement. The 2006 Indian Residential School Settlement Agreement came into effect, and with over almost 80,000 claimants. Of the many recommendations of the agreement that was struck, the most important for this talk is the creation of a Truth and Reconciliation Commission to research the history and legacy of residential schools, struck in 2006, and the National Center for Truth and Reconciliation as a center to house and continue to investigate the IRS system. We've come full circle to the two-row wampum in the goals of the NCTR as a decolonizing archives. We are addressing the progressive loss of cognitive social bonds, community memory, cultural identities, and normative natural laws resulting from the overwhelming assertion of imperial sovereignty and uncompromising colonial settlement. And our goal at the NCTR is to become a decolonizing archive. So what exactly do we mean when we say this? I have 6 points, and if anyone's read the Tandanya Declaration recognizes the similarity, that's because I also wrote the Tandanya Declaration. But so these are the 6 points. A decolonizing archive recognizes the embedded colonial role played by traditional colonial archives. It acknowledges the overlapping multiplicity of rights, provenance, and the diverse meanings embodied in the archival document. It recognizes that archival evidence is not a fact. It is a matrix of relationships. And like all relationships, it is vulnerable to trust and mistrust, good faith and manipulation. It is a living archive, a place of gathering and participation. It does not preserve static records frozen in time, but recognizes their dynamic, evolving intergenerational meaning for communities and individuals. It provides a social memory infrastructure that supports Indigenous cognitive practices, Indigenous knowledge methods, and social protocols. It breaks out of the textual paradigm of archival evidence. It builds on the digital potential to interrelate diverse genres of social memory to create a holistic center of social memory, recognizing the spiritual and environmental in the context of local social sanction. And finally, it offers a safe and accessible space for Indigenous peoples to learn of and freely express their views on the legacy of the IRS experience, and for settler society to listen, encounter, acknowledge, and reconcile. Within the framework of the UNDRIP and its Indigenous vision of governance, rights, and identity, the NCTR is attempting to decolonize a profoundly colonized history. Unstated in its mandate, the NCTR creates a new conceptual space where the holistic and immanent orders and values of Indigenous communities can grow uninhibited, to cross-pollinate with the rational, individual Enlightenment principles of European social thought, and to seed hybrid ideas of immanent order and mutual esteem, to freely grow a colorful garden of collective and individual rights, unhindered by centuries of imperial judgment. To say, I hear you, I see you, and I begin to understand. For ultimately, as I've said previously, we are what we choose to remember, but we're also what we choose to forget. Thank you, merci beaucoup, Kinanesko Metin. should I go have a seat or?
Sorry?
Can I go have a seat? Or?
Yeah, sure. Yeah, we'll take the questions afterwards. So if you have questions, keep them in mind. Our next speaker is Lisa Mullins. She is an archivist, educated at, I hope I pronounce it right, Dalhousie, yeah, and Cambridge University since 2022. She has worked for the Inuit Circumpolar Council, where she is responsible for starting an ICC archive. And this is also the topic of your talk today, right? Yeah. So over to you.
Mm-hmm. Okay, thank you. Can everyone hear me okay? Okay, great. I must begin with a position statement. I do not speak for Inuit, nor do I speak for the Inuit Circumpolar Council. This paper is from my limited perspective as the archivist of the Inuit Circumpolar Council, Canada. I am not Inuk. My job title, archivist, translates to keeper of things that must be kept in one Inuit language. I am so grateful that I get to be the keeper, that I am allowed to care for and facilitate access to the records of one of the oldest and most influential international Indigenous peoples organizations. We know that access to archival records is necessary for sovereignty, for decolonization, for truth and reconciliation, and for healing. Records have power. They can and are used for all the purposes just mentioned, but records also tell stories. These stories can be joyful. Archives can be places for lifelong learning and can facilitate social connections and solidify and create community bonds. However, archives are often uncomfortable spaces for Inuit in Canada. They hold records that document historical violence and ongoing damage and trauma. Most records held in archives relating to Inuit were created about Inuit for non-Inuit purposes, often without consent, and by non-Inuit individuals and organizations. Access to desired records can be extremely difficult due to both active and passive barriers, including common archival practices. The fact that there are not many Inuit professional archivists in Canada should not come as a surprise, and that is the only reason why I have my job. In the ICC Canada Archives, our records and collections are created by Inuit, by an Inuit organization, or on behalf of Inuit, with consent and very much for Inuit priorities. ICC's records are the records of an organization, but they are also a celebration of Inuit success and determination. It is not an Inuit archive, but it is an archive for Inuit. Our newly established repository faces ongoing challenges to find ways of making archives accessible and relevant and culturally appropriate for Inuit, given the negative associations with archives and archival repositories that many Inuit hold. Our underlying theory or philosophy is really simple. Meet our users where they are. Everything we do is about access to information. Everything we do is user-centered. Outreach products and interpretive resources like a digital story or a browsable online database of holdings are not afterthoughts or something you do after you've arranged and described all your records. They are actually the starting points for all archival work. I do not believe that there is a way yet to fully decolonize institutional archives or make them wholly uncolonial. But there are many, many ways that archival repositories can work within existing structures and existing professional standards to make archival practices less Eurocentric or colonial and more welcoming to Inuit users and Inuit ways of knowing. This is very much a practice-based presentation, highlights of what ICC Canada did and what we continue to do. The paper concludes with a very brief discussion of some of the key areas in which cultural heritage professionals need to take action in collaboration with Inuit, so Inuit can access and engage with the full range of their documentary heritage in meaningful ways. Nothing the ICC Canada Archives has done is unheard of. Many scholars, practicing archivists, and cultural heritage professionals, some of whom are in this room, have argued for more inclusive description standards, more appropriate subject headings, et cetera, for many, many, many years. What we've done is put some of these propositions into action and made them the foundation for our archival practices and theories. And we draw inspiration from many Indigenous archives in Canada who are also doing this kind of work. The ICC Canada Archives and our web portal serve as proof of concept for Inuit documentary heritage programs in both Inuit institutional archives and in non-Inuit archives. I am not going to speak about the community-run archives in Inuit Unangat because I am definitely not qualified to speak about them. There are phenomenal community-based and community-run archives in the north that are doing really innovative archival work from a wholly Inuit perspective. And I'm happy to give you website addresses after the chat. You should check them out. They're phenomenal. So Inuit Circumpolar Council Canada, ICC Canada, is a nonprofit organization dedicated to representing the interests of Inuit in Canada on matters of international importance. We bring local and regional concerns on transnational subjects like climate change and marine pollution to international forums where high-level decisions are made on issues that impact the Inuit homeland. We promote, advocate, and celebrate the totality of Inuit culture, knowledge, language, art, beliefs, and stories. ICC Canada is led by a board of directors comprising the elected leaders of the Inuit land claim regions in Canada. Past ICC Canada leaders include environmental activist Sialawat Kluche and Canada's current Governor General and former ambassador to Denmark, Mary Simon. ICC Canada is one of 4 regional offices of the International Inuit Circumpolar Council, which preserves and promotes the unity of Inuit as a single people within the circumpolar Arctic and advocates on behalf of all Inuit. ICC was founded in 1977 when Inupiaq leader Ibn Hobson invited other Inuit leaders to discuss how to provide united, consistent responses to increasing attacks on the Inuit way of life. ICC is now a major international Indigenous peoples organization. It is a permanent participant on the Arctic Council and holds consultative status at the United Nations Economic and Social Council, to name just 2 of its high-level undertakings. And I should note that we also have provisional consultative status at the International Maritime Organization, and we are the only Indigenous peoples organization to ever have any kind of status at the IMO. ICC holds a General Assembly every 4 years, at which delegates from across the circumpolar region elect a new chair and executive council members, celebrate Inuit culture, develop policies, and adopt resolutions that will guide the activities of the organization for the coming term. Every 4 years, the position of chair, the international leader, rotates from one regional office to the next. Currently, Kalaallit Nunaat holds the chairship, and Sarah Olsvig is our chair. These 2 photos were taken 4 months apart. And no, I did not sleep. In July 2022, the ICC Canada Archives was created to preserve and promote the organization's records, which document Inuit knowledge, participation, advocacy, and leadership. ICC Canada's history is part of Inuit history. We are a private archive. As that overview has hopefully shown, ICC is an Inuit organization, but it is an organization that operates in a nation-state-based international system. Each of its 4 regional offices also operate inside nation states with complex historical and ongoing colonial systems. Our records reflect this. Again, ICC Canada Archives is not an Inuit archive, but we are an archive for Inuit. Some types of records we hold are the same kind as you'd find in any NGO, while other types of records are quite unique to Indigenous organizations. Our repository is small, though slowly growing at a rate that I did not quite predict. We hold all of ICC Canada's records and a good amount of records from ICC, mainly from when Canada has held the international chair. While we are an institutional archive, we do accept donations of materials from the private sector in some cases, usually from former ICC leaders or staff. The archives consist of 3 major collections: archives, art and cultural artifacts, and a library. While ICC Canada Archives is located in Ottawa, Ontario, the majority of our users are in Inuit Nunaat. This physical separation between archives and Inuit users is unfortunately common, and it presents a huge barrier for Inuit engagement in their own documentary heritage. We provide access to our collections through an online archives web portal. This is not perfect. It overcomes the barrier of distance for some users, but still presents significant issues for users with unreliable internet, and also users with digital literacy issues. We welcome in-person Inuit users to visit. Non-Inuit individuals may visit the archives, but must apply by permission. Our space is very informal, and we think it's quite welcoming for researchers. The ICC Canada Archives web portal was designed, created, and launched to the public in 10 months, from March to December of 2023. This slide and the next one show a rough timeline of its development. There was a lot of 2 steps forward, 1 step back over these 10 months. The web portal consists of a searchable database of our collections and a variety of interpretive resources or outreach features. The database is by no means complete. I cannot stress that enough. Less than 10% of our archival holdings have been described. That's the problem when you start an archive. You start with 100% of backlog. But there is still a good amount of content in all 3 of the major collections. There are new additions to the archives collection literally every week, with significant record additions expected every 2 months. An important reminder that an online database of records does not mean the records themselves are online. While we are digitizing hundreds of archival records in various media, the vast majority of records will not be online for a whole host of reasons. The ICC Canada Archives are for Inuit. It was a given that all aspects of the archives web portal had to be available and functional in English and Inuktitut. The primary requirement for our online archives database was therefore the ability to index, search, and display English and Inuktitut in its 2 distinct written forms, Roman orthography and syllabics. These language requirements shaped a significant database decision, namely, what content management software we could use. Our collections database is one of the only cultural heritage catalogs fully functional and available in an Indigenous language in Canada. Every single thing that goes into the archives web portal is or will be in English and Inuktitut. At present, there is more content in English because I am not fluent in Inuktitut. However, we just received 2 grants, substantial grants, that will enable a lot of translation and quite a bit of content creation in Inuktitut. Our content management systems are Artifactual's Access to Memory, or A2M, and Apple's FileMaker Pro. We were extremely limited in our options. Although Inuktitut it is a Unicode font, finding a content management system that actually displays it correctly is a major challenge. A2M is an industry standard CMS in Canada for archives, and it can be set to a variety of descriptive standards, but using FileMaker Pro was definitely a compromise because it's a very, very basic database. Multiple content management systems were required because our 3 collections require 3 distinct metadata standards. When I was choosing CMSs, none had an interface in Inuktitut, and very, very few providers were willing to even entertain the idea. Luckily, Andersen Consulting, who are based in Vancouver, was eager to take on the challenge of developing a dual language English Inuktitut cultural heritage database. I should mention that there are other CMSs out there that can handle Inuktitut, but those are not compatible with third-party hosting. Our content management system had to have open APIs and the ability to be hosted by a third party because of the interface display language. Hand in hand with language was the imperative of federated searching. Remember, we're meeting users where they are. For searching, that means Google. Our search function needed it to be as intuitive and as easy to use as Google, but without the ads. Andi, A-N-D-I, is our discovery interface. It searches the contents of all of the descriptions, as well as inside digitized records, providing they've been OCR'd, all from one box on the homepage. We customized our Andi interface with a focus on user convenience, including features such as selections and permalinks, allowing users to save and share material they are interested in. There is a feedback button on every single database record, making it really easy to contact the archive staff about specific items of interest, or provide more information and hopefully correct any errors if we've made them. Andy also answered our need for a web portal that functions equally well on mobile devices as well as desktops. And in the top image there, that's just a short view of a record, and those are all the buttons. And those buttons are on every single record in every collection in the database. A robust browse function was also imperative. We expect nothing of our users except curiosity. Most archival repositories are geared to amateur and professional researchers. It is expected that users are coming to the archives with some expectation of what kind of materials are housed there, and that those materials can help them find something that they are looking for. Our Andy interface supports research-driven users and sophisticated research querying, but the ICC Canada Archives web portal is designed for a curiosity-driven user. The ability to browse the collection in multiple ways was key. The first kind of browsing is on the homepage. Users can browse each of the 3 collections, archives, art, and library, separately, rather than everything jumbled together. The second and more interesting kind of browse allows users to browse by name, keywords and subjects, and places, pulled from all 3 collections. This groups records into more relevant factors to our users instead of by record series. By scrolling through the list, users can also get an idea of who is involved in our collection, where events took place, and what kind of events and topics are covered. Users can also browse through the More Like This button, which is available on every catalog record. Clicking More Like This, results are gathered and sorted based on the full description of the catalog record, and clicking on it often reveals unexpected relationships and linkages across file collection that even myself as the processing archivist didn't realize. The browse function in Andy is definitely not perfect. Andersen is willing to write substantial chunks of new code for us, but we need a chunk of funding because it's a lot of programming work. Andy hides our actual content management systems from the public view. Using a separate discovery interface allows us to diminish confusing professional jargon in our public-facing archives web portal while still following professional metadata standards in the underlying databases. Users see description field labels like "about these records" instead of scope and content. Which field labels we decided to reword were directly informed by user testing with delegates at ICC events. Outreach activities and interpretive resources are another side of access. An online collections database with robust archival descriptions enables users to locate and use archival material. However, without targeted and really specific outreach to announce the existence of the portal, it's quite a bit less likely it'll actually get used. Providing interpretive resources and doing outreach activities can take many forms. Some require really little effort, but can have huge impacts. So for example, we created a common list of acronyms for organizations, projects, and government departments that are found in our records. International organizations, especially, and governments love acronyms. The list took about 3 hours to put together and put online, and we can add to it easily when we realize we've missed one. It's obviously useful for archive users, but we've received far more feedback about this than I expected. My colleagues at ICC Canada love it, and I've gotten messages from staff at other Inuit organizations who've reached out to say how helpful this is in their work. One interpretive resource that we launched with the Archives web portal is a multimedia digital story, the Inuit Express, ICC Canada's humanitarian aid to post-USSR Chukotka, tells the story of how ICC Canada rallied Inuit in Canada to provide life-saving aid to Inuit and other Indigenous peoples in Chukotka in partnership with the Red Cross. Storytelling is a key part of Inuit life. Inuit teach and share their most important information through stories and in story form. It's hard to overstate the significance of the act of storytelling. It was necessary then for us to incorporate some kind of structured storytelling into the Archives web portal. This digital story combines elements of narrative history, a museum exhibition, and a research guide into a fact-based multimedia story tale with text, photographs, and video clips. The story integrates information from records in 5 different fonds and from our art and archives collection. It points out connections and builds interest in a wide variety of our holdings. There are links to archival descriptions and digitized records throughout the entire story. The digital story enables access to information, to Inuit history, in the archives, albeit interpreted by us. However, while the story is told in a linear fashion, the abundance of links provide users with opportunities to explore, learn more, and assemble information in their own way to create their own analysis if they want. The Inuktitut version of this story has just been translated, and it should be online, hopefully, within the next week or 2 weeks. And we have many more stories in the works. Archival descriptions follow national or international professional standards, and these are important. The metadata schemas ensure descriptions from archival repositories have the same general structure and the same type of information, and this is really key because of the rise of linked data and the dominance of online searching. But these professional practices also create barriers to access, as the previous example in technical language shows. I could say a lot about archival description, but I'm going to try and keep it as general as possible so the non-archivists in the audience don't fall asleep. ICC Canada Archives uses the Canadian rules for archival description for reasons that have actually nothing to do with the standard, and we use the international ISAAR for authority records. Contrary to most archival repositories, we practice exhaustive description. Countless studies by academic researchers and working archivists will tell you that more description equals more access. The majority of our users are remote and cannot easily access our physical holdings. The database has to have as much information as possible. A key description practice for the ICC Canada Archives is the use of access points. Every single database record has at least one access point in addition to record creator. We use name access point, subject or keyword access points, and geographic place access points. All 3 of our collections use the same access point taxonomies that we created. So clicking on an access point brings up all database records that have that tag. We had to create our own name, subject, keyword, and place taxonomies because standard ones are racist. I'm not going to pretend they're not. They use racist language, or they're simply just irrelevant to our Inuit users. This is part of exhaustive description and is absolutely necessary for better access. I cannot stress this enough. It allows our users to take a different path to discover the same information. We have reimagined the subject access point as a keyword point instead, like a tag on social media. Right now, it's currently a mess of formal subject headings, like structured, like formal subject headings and plain language keywords. And honestly, I tidy it up a little bit every week based on user feedback and the contents of more records as they are processed. I have to do a shout out to the Inuvialuit Digital Library because they are a fantastic source of tags that are already in use. Current descriptive standards and common description practices do not necessarily work for ICC Canada's records or users. Many of the reasons for this are because of Inuit conceptions of information and knowledge production and the emphasis on community over individual. Let's look at date, which should be like a given, but it's not. We have a font with over 100 maps documenting Inuit trails across the land, sea, and ice of Inuit Nunangat. The standards for date, with a focus on creation and collection, are not sufficient for records like these maps that contain or are based on Inuit knowledge. Inuit knowledge with a capital I and a capital K is often referred to as traditional knowledge, does not belong to one person. It is communal and passed down from elder to youth, from parent to child. Because archival description rules are for the record and not the information it contains, following professional standards around date actually diminishes the meaning, the value, and the evidential weight of this record. In the date field in our archival descriptions, you'll find entries like this: shared in 2017, based on knowledge passed down through generations. This brings us to a handful of issues around the concept of record creator. The entity types that can be record creators is not comprehensive of Inuit ways of understanding and knowing. We definitely have Inuit corporate bodies in our records. ICC Canada is a corporate body. But we have creators who do not fall in the 3 prescribed categories of person, family, or corporate body. We have a much broader definition of creator, which I would argue is more aligned with how records are actually generated. In several Fawn series, we have records created by communities. The community of Saxe Harbor, the community of Gris Ford, and the community of Mitti Matalik. Issues with creator entity types are closely related to issues with 2 foundational archival principles, namely respect des fonds and provenance. Many, probably as much as half, that's a conservative estimate, of our records have multiple creators. Again, part of this stems from the fact that we are an institutional archive, and describing all our records as created by ICC Canada is just unhelpful. Sole creatorship is also simply not reflective of the actual process of creation for all records. It's also, again, not aligned with central aspects of the Inuit worldview. The archival concept of creator just does not make sense to most non-archivists. Series and records within Fond often have additional creators not represented at Fond level. The World Council of Indigenous People is a series in the ICC International Fond. It has 3 creators: ICC, the World Council of Indigenous People, and Hans Pavia Rosing. This series documents Hans Pavia Rosing's participation in the World Council of Indigenous Peoples. Though he was chair of ICC, he was not representing ICC at the WCIP. However, all his records related to the WCIP ended up in the ICC head office, where they were used and added to. ICC Canada Archives very much subscribes to the provenance plurality theory, articulated best by archivist Jessie Boiteau at the NCTR, which focuses on relationships between creators to provide context and organization for records, instead of adhering to a strict respect des fonds and provenance. The ICC Canada Archives has a lot of plans to increase Inuit access to our collection. We have a lot of arrangement and description to do. We have big plans for new outreach activities and interpretive resources as well. We want to create a direct access point from the portal launch page to all the photographs in our database. We are planning tea and bannock sessions with Urban Inuit in Ottawa to identify photographs. And we really, really hope to get funding for an elder and youth internship to actually work in the collections. The portal is also scalable. The other ICC regional offices are exploring ways to join. Especially, we wish for the capacity to launch a Kalalisut version of the portal. I hope the decisions and actions I've described, yes, pun intended, suggest areas where the Canadian and international archival communities need to concentrate their work to make archives more accessible and welcoming to Inuit. It will be to no one's surprise that a revision of archival description standards are near the top of this work plan. Equally important on this work plan is a series of tasks related to language. Like many Indigenous peoples, language and culture are inseparable for Inuit. In translating the database interface, ICC Canada and its translators have actually had to create new words in Inuktitut to reflect archival and cultural heritage concepts. And we still don't have words for a few terms. Developing this proof of concept cultural heritage web portal revealed a need for collaboration between Inuit and non-Inuit cultural heritage experts and Inuktitut language experts. Closely related to this is the need for technologies like content management systems to function in a much wider variety of languages and scripts. Linguistic inclusion is a form of decolonization and reconciliation. Kalalisut and Inuktitut were not options in our content management systems when I first got them. I had to actually contact both developers and get them to add it to the official drop-down menu of languages. While Inuit in Canada wait for more control of their own documentary heritage that is held by non-Inuit institutions, there are, in the meantime, many, many ways in which archives can make documentary heritage immediately more accessible and welcoming to Inuit users. Ask what Inuit communities want to learn or discover in your collection. Inuit and non-Inuit archivists, academic researchers, and Inuit communities and groups need to collaborate. Practice exhaustive description for those identified topics or record sets of interest. Don't assume all your users are researchers. Encourage and enable curiosity and unexpected discovery. Use more access points. Make sure your key resources, like registration forms for in-person visits, are available in Inuktitut. Small outreach activities and simple interpretive resources can have big impacts. Just meet your users where they are. Thanks very much.
Thank you so much, Lisa. We are now moving on to the coffee break. We have a, we'll take the coffee break now, 10 minutes, and then reconvene here. 20 past, previously in my life. Deputy Director at the, sorry, I have to say this is full circle for me, because I started my academic career as a student assistant at the Arne Magnian collections here in Copenhagen. Not knowing anything about what you're going to talk about. But Deputy Director at the National Archives of Iceland, Sigurðsson has worked in the archival sector for 24 years and been at the National Archives since 2006. He was also a seasonal lecturer in the archival studies at University of Iceland, 2012 to 2022, and from 2016 he has chaired the International Council on Archives, the ICA expert group on shared archival heritage. And he's presenting together with Bjarni Magnússon, Professor of International Law and Dean at the Faculty of Law at Bifröst University, Iceland. His research includes a wide variety of questions of international law, also including the Danish Icelandic Act of Union, 1918. And just to mention, now we talked about previous DIIS seminars. There's actually also a seminar on this specific act, which Rachael was also part of some years back. Yeah, please come forward.
Now? Yes. Fantastic.
Do you hear me? No. Louder. What about now?
No?
It's unmuted. All right. Can you hear me now? You just have to wait a little bit. Okay. Yeah. Now. Wow. Okay. No problem. Thank you, and nice to be here in Copenhagen. Me and Bjarni have a joint presentation, and I will take the first part, and then he will swiftly take over, and then I will finish the presentation. And our presentation is called, "Did the 1918 Danish Icelandic Act of Union pave the way for transfers of manuscripts and records to Iceland in 1928. In 1928, documents and records concerning Iceland were transferred from Denmark to Iceland according to a bilateral treaty between the two countries. This transfer is called the Danish Delivery of 1928 and contained many of Iceland's most valuable documents and basic sources on the country's history in previous centuries. Among the documents delivered to Iceland in 1928 was the census of 1703, which is preserved in the Rentekammers archive in the National Archives of Iceland. But it was included on the UNESCO list of World Heritage in 2013. And this is the only Icelandic document, together with Árni Magnússon manuscript collection, on that list. In this presentation, we will discuss the history of the Danish delivery of 1928 and the role of the 1918 Danish Icelandic Act of Union in that matter. Iceland was part of the Norwegian crown from the 12th century and later the Danish state. Following political turmoil in Europe in the first half of the 19th century, nationalism arose in Iceland, which, among other things, took place in increased interest in Icelandic culture. For example, Icelandic language, ancient literature, and the history of the country. At the same time, Icelanders began a peaceful struggle for the reconstruction of the parliament, Alþingi, and Iceland's position within the Danish state and later the nation's independence from Denmark. The attitude towards Denmark became the focus of the political debate in Iceland in the 19th century, where it was believed that the poor condition of the country and the people could be traced to the lack of understanding of foreign governments, and when power came to Iceland, all obstacles would be removed and the way to further development would be easier. It was also important that the Icelandic nation could separate themselves from the colonial power. To do so, Icelanders referred to the identity of the nation that could be found in the history of Iceland and the Icelandic language. And in this atmosphere, the first archival claims against Denmark were submitted. And in fact, it can be said that the attitude towards Denmark and the steps taken forward towards independence in the 19th and 20th centuries were always in the background in all discussions about the archival claims. Formal archival claims against Denmark did not emerge until 1907, when Alþingi, the parliament, passed a resolution on the matter. And it can be assumed that due to Iceland's position within the Danish state, such claims would have not have been very effective if they had been presented earlier. In addition, there were no good infrastructure for archival preservation in Iceland. The National Archives was not established until 1882, and the first employee was hired in the year 1900, and specially designed premises for the operation were not taken into use until 1908. Interest in the return of Icelandic documents and manuscripts from Denmark must also be put in context of Iceland gaining home rule from Denmark in 1904, and the emphasis on building up the infrastructure of the society. The archival claims from 1907 demanded that Denmark would return to Iceland all documents and manuscripts from public offices that Árni Magnússon, an Icelandic scholar and a manuscript collector, had borrowed and transferred from Iceland to Denmark in the 18th century. Jón Þorkelsson, who was the first national archivist in Iceland, wrote in 1905 about the importance of those documents and records for the country and the nation. And those words show very well why the archival claims were put forward. And Jón said, and I'm going to read this in Icelandic, you have the English translation here on the screen. Og áríðandi að menn ekki gleymi því að hér verið að reyna að vernda eignarrétt í landinu og varðveita ókomna tíma menjar og minning vorra eigin manna og sjálfara vor, minning vorrar eigin þjóðar. The parliamentary resolution proposal was approved, and Jón Þorkelsson the National Archivist, was commissioned to prepare a report on what official Icelandic documents were preserved in Denmark. The Danish government sent the claims to the Árni Magnússon Institute, the Royal Library in Copenhagen, and the National Archives of Denmark for comment, all which rejected the demands from Iceland. The chief librarian of the Royal Library pointed out, for example, in a letter to the Danish government, that it could be a dangerous precedent to accept the demands of Icelanders, as a number of manuscripts and documents from other countries were in the library, and therefore other countries could also make demands. There were, however, no results in the archival claims in 1907, and it seems that this issue was overshadowed by the dispute between Iceland and Denmark at that time over the relationship between the states at that time. And Bjarni.
So following the cessation of hostilities in World War I, Iceland and Denmark entered into a bilateral treaty known as the Danish Icelandic Act of Union, aimed at delineating the sovereignty of Iceland within the framework of their future interrelations. Entered into force December 1st, 1918, this treaty presented in parallel national legislations in both Danish and Icelandic languages, formalized the status of Iceland and Denmark as autonomous and sovereign entities under a shared monarchy. Notably, the treaty did not explicitly address archival matters. Conversely, the Act facilitated avenues for enhanced collaboration through the establishment of a joint Danish-Icelandic Advisory Council comprising 6 members. Convening annually until 1939, the council convened at the Alþingi, the Icelandic Parliament, and Christiansborg Palace, and functioning as a consultative body devoid of decision-making authority. Its primary mandate, according to the Act, revolved around the practical implementation of the Act and the deliberation of legislative proposals pertinent to the specialized concerns of one state that held implications for the other state and its citizenry. The official commentary to the treaty notes that the Council's purpose is also to promote cooperation between the states. It is not clear whether this is a general statement or in the context of legislative cooperation. It is, however, clear that there is no such general statement in the text of the Act. Shortly after the Act was concluded, the disputes over the relationship between Iceland and Denmark subsided. However, amidst this newfound stability, the issue of archival claims resurfaced in Iceland. In response, the Icelandic Parliament embarked upon a re-evaluation of its archival demands, which now extended beyond the ambit of the Árni Magnússon Institute's holdings, as was the case in 1907, to encompass documents of Icelandic provenance housed within the National Archives and the Royal Library. This renewed pursuit of archival claims provoked a more receptive reception. Although from the viewpoint of a textual interpretation, there was very little room to decide that the Danish Icelandic Advisory Council was the right forum for archival claims because its role was supposed to focus on specific legislative activities. Both states opted to utilize the council as the designated platform for addressing these concerns. Consequently, the council decided to convene a specialized subcommittee to undertake a comprehensive inquiry into the issue. The utilization of the Danish Icelandic Advisory Council as a mechanism for addressing archival claims offers a pertinent illustration of the strategic effectiveness inherent in establishing diplomatic fora for intergovernmental dialogue in treaties. This adaptive approach to international commitments underscores the potential for the evolution of such forums to accommodate broader mandates through subsequent agreements or practices among treaty parties, thereby obviating the need for renegotiation and the formulation of novel commitments. The reason why the Icelandic archival claims were better accepted by Denmark in 1924 than 70 years earlier can be traced to the fact that the position of Iceland and Denmark had changed with the Act of the Union. Iceland now stood on an equal ground with Denmark as a sovereign state, at least according to the Act. The Act of Union between Iceland and Denmark in 1918 also established this channel, the Danish Icelandic Advisory Council. Therefore, a channel had been created to continue working on such matters as archival claims. It can also be assumed that news of Norway's archival claims against Denmark at the same time affected Iceland's decision to make archival claims against Denmark. And also, at the same time, the Danes themselves had received documents and artifacts from the German state concerning North Schleswig, which Denmark took over in 1920. It can therefore be said that Iceland's negotiation position had changed since the first formal archival claims were presented in 1907. Njörður.
It's interesting to look at the decision about the archival claims, both in Alþingi, the parliament, and within the Danish government. In discussion about the proposal in Alþingi, it was referred to that Icelanders had every right to receive manuscripts and documents that Árni Magnússon had borrowed at the time. It was also mentioned that these documents and manuscripts were part of Icelandic culture. In Denmark, the point of view was that many of the manuscripts had been gifts or they had been bought. So they were, by law, the property of Denmark. It was also pointed out that the manuscripts and documents were more accessible for scholars in Copenhagen than in Reykjavik, because they had been there for over 2 centuries. The matter was taken up at meetings of the Danish Icelandic Council in 1924, but mostly in the summer of 1925. The council received various experts from both countries for advice. An agreement of the archival claims in the form of a bilateral treaty was basically reached at the end of the summer of 1925. However, the agreement did not enter into force until 1927, and the delivery of documents took place in 1928. In all the negotiations, the Danes were of the opinion that documents that were equally important to both countries would not be handed over, but only that which concerned Iceland altogether or partly should be transferred to Iceland. Due to this, no documents concerning the Danish trade in Iceland in 17th and 18th century were handed over. No manuscripts from the Árni Magnússon Institute nor the Royal Library were returned, except for the diplomatic documents that were part of archives of public authorities in Iceland. And that story did not really end until 1971, when an agreement was reached after a great struggles by the Icelanders that Icelandic manuscripts would be returned to Iceland. And this history of the return of Icelandic manuscripts from Denmark may not be over yet, because in 2019, the Icelandic Minister of Education, Science and Culture came forward with the new demands for return of Icelandic manuscripts. And it's not yet clear how that matter will end. It is interesting to note that an agreement was reached on mutual exchange of documents between the nations, and not only on the return of documents from Denmark to Iceland, as was the original claim from Iceland. Hannes Thorsteinsson, the national archivist in Iceland at this time, said in his autobiography that it was the initiative of the Icelandic Prime Minister to offer documents to the Danes in exchange, and that he believed this facilitated agreements. Denmark's argument was that they felt it necessary to have documents concerning the management of Icelandic affairs in Denmark. As a result, Denmark received letter books, letter lists, and proposal books from the Icelandic Government Department, which was a Danish institution dealing with Icelandic affairs that operated in the years 1848 to 1904, when the Icelandic cabinet was established. Those documents, including the original of the first Icelandic constitution from 1874, found their way to Iceland again in 2003 with a special agreement between Iceland and Denmark on the return of those documents, and they are now preserved in the National Archives of Iceland. With the 1927 archival agreement, a total of 830 books and archives packages concerning Iceland and Icelandic issues were delivered from the National Archives of Denmark, mostly from the 16th century to the middle of the 19th century. Books of Alþingi, the Icelandic Parliament, and other official books were transferred from the Royal Library, a total of about 20 volumes. From Árni Magnússon Institute, about 700 Icelandic parchments and 3 parchment books. In addition, court documents in Icelandic cases were handed over from the Danish Supreme Court, the youngest to the year 1921, a total of 6 archival boxes. It can be estimated that the total volume of these documents is about 120 shelf meters. Sources show that the leaders in Iceland in these negotiations thought they had made a good agreement, and that the documents that went back to Denmark were a small leverage compared to what was obtained from Denmark. And to conclude, and to answer the question that we asked at the beginning of this presentation, yes, the 1918 Danish Icelandic Act of Union did pave the way for transfer of records to Iceland in 1928. With the utilization of the Danish Icelandic Advisory Council, which the Act facilitated, a channel or a mechanism was available to use for the resolution of complex disputes between 2 countries, such as archival claims. But it must also be taken into account that this mechanism is not enough on its own. Other factors did have considerable effect on the results, including repatriation of documents and artifacts from Germany to Denmark in 1920, that the agreement was bilateral, and that the 2 countries were on good speaking terms following the 1918 Act of Union. Thank you.